The Nolan Wells investigation just got even more complicated. We now have threatened legal action against the Reverend Al Sharpton, a fight over how Nolan Wells' phone will be examined, and dun dun dun, the prosecutor saying that, hey, we are not going to release any information on this thing. We're going to keep it sealed until it reaches a grand jury. So instead of getting clear, the battle over who gets to say what.
First, a boat trip that turned into a missing person investigation. Then a family demanding answers the state won't give. Then 3 friends getting lawyers who want to silence the people asking questions. Second, a phone that nobody can agree on how to examine, because the chain of custody, the access to data, who gets to see what all contested. Third, independent autopsy results that don't solve anything. They just say undetermined, pending further evidence. Fourth, sealed records, grand jury secrecy, a prosecutor saying nothing public until a jury decides if there's enough to charge anybody. And fifth, here's the thing nobody's talking about enough: the legal battle over what happened might reveal more truth than the official investigation actually wants revealed. That's where we are with Nolan Wells. Not in the facts we know, but in the fight over which facts get to matter. So let's separate what's documented from what's speculation, what's legal strategy from what's actual evidence, because the narrative gets louder every week, but the documented record, it's getting harder to see. Nolan Wells went missing. That much is settled. The circumstances around those missing hours, what happened on the boat, what the evidence actually shows versus what people think it shows, that's where the record starts to fracture. On that day, this person who people describe as hardworking, goal-oriented, respectful, caring, he was out on a boat with 3 friends: Warren, Hudson, Jack Patalo, Morgan Seymour. They knew him. They were with him. And something happened that nobody outside that boat can fully confirm from the physical evidence alone. He ended up dead. His body was recovered. An autopsy was performed by the medical examiner. Then an independent autopsy was ordered. And both of those autopsies reached the same conclusion: the cause of death, the manner of death, pending further evidence. Not murder, not accident, not natural causes. Undetermined. That word is doing a lot of work here. It's not a resolution. It's a placeholder. It means the doctors looked at the body and couldn't tell you with confidence how this person died, just that he did. The media picked up the story. Allegations started circulating about what might have happened. The family started asking harder questions. And then things got legal very fast. The friend's attorneys sent a cease-and-desist letter to Reverend Al Sharpton, demanding retractions and apologies for statements they say falsely implicated their clients in Nolan's death or disappearance. The letter is real. The threat of a defamation lawsuit is real. But here's what makes this procedurally weird: Al Sharpton's response, his actual position, is that he's not scared of the lawsuit, because a defamation lawsuit could trigger discovery, deposition, sworn testimony, things you lie about under oath. You're facing perjury charges, not just reputation damage. He's basically saying, you want to come at me? Fine. Let's go to court. Because court means witnesses get put under oath.
Al Sharpton has now been threatened with a defamation lawsuit. Attorneys representing Warren Hudson, Jack Patalo, and Morgan Seymour sent Al Sharpton a pre-suit demand letter demanding apologies and retractions over statements they say falsely implicated the 3 friends.
Now, that's a gamble, but it tells you something about confidence in the investigative path. If you're threatened with a lawsuit and your response is bring it on, because then we'll have discovery, you're betting that sworn testimony helps your case more than it hurts it.
So the question becomes whether litigation intended to stop accusations could actually expose more information. That's really what it's about. And here's the deal, fam. I don't think they want that. I don't think they want that. I really don't think they want to see all of that.
The phone is the thing everybody's fighting over. Nolan's phone. There's supposed to be a forensic examination. The family wanted it done. The prosecutor wanted it done. But how it gets done, who gets access to what data, what happens to the device afterwards? That's where they stopped agreeing.
Then there's Nolan's phone. The family and the DA previously agreed to a jointly coordinated forensic examination, potentially involving the Mississippi Gulf Coast Community College Digital Forensics Lab and possibly the FBI. The disagreement appears to be over how it's done, not simply whether it's done. The family has sought an agreed forensic protocol covering chain of custody, preservation, access to extracted data.
A forensic examination of a phone can extract deleted messages, recover old calls, show location data, show timestamps for when things happened. It can reconstruct those final hours, or it can show that nothing suspicious happened at all. The phone is evidence that could either support criminal charges or undercut them, which is why everybody wants it examined carefully, but carefully in different ways. The family's position: we want a jointly coordinated forensic protocol. We want the chain of custody documented. We want agreement on what data gets extracted, how it's preserved, and what happens to the device after. That's not paranoia. That's how evidence integrity actually works in cases that might go to trial.
Device afterwards. Now, I can tell you from personal experience, after they go through your phone, it's still your phone, so eventually they do return the phone to you. No matter what they find on it, they typically will return the phone.
The prosecutor's response: the device is in our custody. The examination will happen, but we're not negotiating the protocol with anyone. And in terms of public transparency, whatever we find stays sealed until the grand jury review is complete. Pause on that for a second. Allegations have circulated for weeks. A family is asking questions. The public knows something happened, but official evidence is sealed pending grand jury review. That means the public doesn't get to know what the autopsy found, doesn't get to know what forensic evidence exists, doesn't get to see the state's case or the defense. And that secrecy is legal. It's standard procedure in active investigations. But it's also a procedure that protects the prosecutorial narrative from public scrutiny until a jury is already selected.
Meanwhile, you got the public. The public isn't getting the state's evidence yet. The DA says investigative evidence and the state autopsy findings will remain sealed pending grand jury review. That secrecy has two sides. Prosecutors argue they're protecting the integrity of an active investigation and grand jury process. Nolan's family and the public understandably want answers.
Here's what actually gets overlooked in coverage like this: the independent autopsy. That exam happened outside official channels. The results came back undetermined. Cause of death, undetermined. Manner of death, undetermined, pending further evidence. But what people do with that information is they treat undetermined as suspicious, like the doctors were avoiding a conclusion. That's not accurate. Undetermined means the forensic pathologists looked at the body, found no definitive cause, and said so publicly. That's integrity. But it also means they didn't rule anything in or out, which is why the phone matters. Phone data could help determine what happened. Or it could be irrelevant. That's the thing the forensic examination is supposed to answer.
Nolan's family and the public understandably want answers right motherfucking now. Now let's talk about the independent autopsy. The independent autopsy hasn't solved the mystery either. It's classified Nolan's cause and manner of death as undetermined, pending further evidence. Yeah, pending, well.
Let's talk about what allegations actually are and why it matters that we distinguish them from evidence.
It's important to understand this, fam, that allegations aren't evidence. Okay? So what do they have to be afraid of? I mean, it's just allegations. Allegations are not evidence. So why are they shaking so much? These so-called three friends, as attorneys maintain their clients had nothing to do with Nolan's disappearance, are dead.
Three friends have been named in public discussions about Nolan's death. Allegations have circulated that they were involved. Those allegations have spread through social media, podcasts, message boards. They've built a narrative. But here's the structural problem: allegations are not evidence. Allegations are claims. Evidence is documented facts that a court or a forensic examiner can verify. The friends deny involvement. Their attorneys deny their clients possessed or accessed Nolan's phone. They deny knowledge of what happened. Those denials are also not evidence. They're claims. But in a court of law, allegations without evidence don't survive scrutiny. If someone accuses you of something and there's no physical evidence, no testimony that holds up under cross-examination, no documented proof, then the accusation collapses under the weight of a defense attorney who knows how to work. That's why Al Sharpton thinks a defamation lawsuit actually helps his position. Because if this goes to depositions, if the friends' attorneys try to prove that Sharpton's statements falsely implicated their clients, they'd have to introduce what the false statements were. And then the defense gets to examine whether there was any evidentiary basis at all for those statements. If there's no evidence, the statements look like unfounded accusations. But if there's some factual basis, even if disputed, then the lawsuit becomes discovery, testimony, fact-finding under oath.
Because them dudes who was on that boat, those dudes who are named in the lawsuit, they not going to be able to hold it together under cross-examination. Yeah, when you put those experienced lawyers on them, it's going to be different than going into that friendly territory where you got black people hate them, Tatum, interviewing them in a nice, comfortable.
Here's where media literacy matters. The louder narrative is not always the stronger evidentiary position. Sometimes the narrative is exactly what someone wants you to focus on because it distracts from the absence of documented proof. And sometimes the person staying quiet about details is doing so because secrecy actually protects their investigative position. In this case, the prosecutor is staying quiet. The state's evidence is sealed. We don't know what the DA has. We don't know if they're building toward charges or building toward closing the case unsolved. That secrecy is infuriating to a family looking for answers. It's also standard practice. But the combination of sealed evidence, contested phone examination, and legal threats around public statements, that's a situation where the truth is actually getting harder to access, not easier. So here's the thing people keep getting wrong about this case. They treat it like a television mystery, where secrets are hidden and smart people figure out the truth by finding the one clue everyone else missed. But this is real. The clues aren't hidden by a writer. They're hidden by procedure, by criminal investigation standards, by grand jury rules that say you don't release evidence to the public before a jury is seated, by forensic protocols that require chain of custody so ironclad that if someone mishandles evidence, it can't be used in court, by prosecutorial judgment calls about what gets pursued and what gets closed. Nolan Wells was a person, not a mystery. A person with a family, with people who loved him, with people who are trying to get answers about how he died, and the system designed to answer those questions. The investigation, the medical examination, the legal process. That system runs on information the public isn't privy to. That doesn't mean there's a cover-up. It means there's a process. And the process is designed to protect the integrity of potential prosecutions and to protect the accused from trial by media. Both of those are important. But they also mean that a family and a public trying to understand what happened are working with incomplete information by design. The independent autopsy was supposed to break that deadlock. An outside examiner, not part of the official investigation, looking at the same body and rendering a finding. Cause undetermined. So that didn't solve it. The phone examination is supposed to be next. Forensic data recovery that might show calls, messages, location, sequence of events. That might show a conspiracy or clear someone's name. But the examination is contested. The protocol isn't settled. The access to results is disputed. And in the meantime, a legal threat against a public figure who commented on the case has opened up the possibility of court discovery that might actually force answers out. Not through investigation, through litigation.
Digital evidence remains contested. The state's evidence isn't public. And ultimately, a grand jury could decide whether the evidence supports criminal charges. Give me a thumbs up, fam, if you think the evidence supports criminal charges.
Here's what's actually underexplored in coverage of cases like this: the role of litigation in discovering facts that an investigation doesn't want to reveal. A criminal investigation is building toward a prosecution, or it's not. If it's building toward charges, the DA has incentive to keep evidence sealed because premature disclosure can harm the case. If it's building toward closing the case unsolved, the DA has incentive to keep evidence sealed because public doubts about the investigation look bad. Either way, secrecy serves the prosecutor's interest. But a civil lawsuit, a defamation case, for example, that runs on different rules. Discovery in civil court can force the production of documents, recorded statements, emails, anything relevant to whether a statement was made knowingly and falsely. If the friend's attorneys sue over statements made about their clients, the plaintiff's side can demand to know what factual basis did you have for saying this? Who told you this? What documents support it? And those questions get answered under oath. That's why Sharpton's confidence in that scenario makes strategic sense. A defamation lawsuit could actually force disclosure of the factual basis for allegations that have been circulating, which either supports those allegations with evidence or reveals that they were made without sufficient basis.
He reminded everybody that, as we, pursue these narratives and we talk about the phone, we talk about who was on the boat, we talk about the seat tow call, we talk about the DA's lack of transparency, the threats being made, all of these different things that that dominates the headlines in this case.
The friend's attorneys probably understand this too, which is why the threat might be that, a threat, a negotiating tactic. If they actually file suit and lose, they've opened their clients to cross-examination that could be worse than the allegations they're trying to stop. This is not abstract legal theory. This is how cases like this actually move, not through investigation alone, but through the incentives created by different legal procedures. Criminal secrecy, civil discovery, public pressure, family persistence. All of those push the system in different directions. Now, here's where I want to be precise. We don't know what the evidence shows. We know an autopsy couldn't determine cause of death. We know a phone needs to be examined. We know allegations circulate, but haven't been proven. We know the prosecutor is keeping evidence sealed. We know 3 people deny involvement. We know a family is still asking questions. That's what's documented. Everything else is interpretation. When someone presents a theory about what happened to Nolan Wells, ask them, where does that come from? Is it from an official statement, from court filings, from the forensic report, or is it from media coverage that quotes unnamed sources, or from internet speculation, or from someone's interpretation of incomplete facts? Because there's a real tendency in cases like this, and I've watched this happen over and over in true crime coverage, for people to present their theory as if it's established fact. And the louder they present it, the more people believe it, the more it becomes accepted, until suddenly the theory is part of the narrative even though it was never proven. That's how myths about cases get started. Not through evidence, through repetition.
And that is Nolan Wells. And the question, what happened to Nolan Wells? How did he die? How did he die? That's important, but it's also important to remember who Nolan Wells was.
So what actually needs to happen for truth to emerge here? The phone gets examined. Forensic results come back. Data is analyzed. That takes time, maybe weeks, maybe months. Maybe the results don't answer the question because the phone was destroyed, or because the relevant communications happened face to face, or because the data points in multiple directions. A grand jury convenes. The prosecutor presents evidence. The grand jury decides if there's probable cause to charge anyone. That could result in charges, or it could result in no charges. Either way, once a grand jury votes, more information becomes public. Or litigation forces discovery. A lawsuit produces depositions, documents, testimony. Some of that becomes public record. In any case, the picture becomes clearer as procedures actually run. which is hard to sit with when you're a family waiting for answers. The system is slow. The system is designed to protect the process over speed. Neither of those helps the people trying to understand how their loved one died. But that's the structure we have. And pushing that structure faster, or bypassing it with media pressure or public allegations, can actually make it harder to prosecute anyone if evidence is contaminated or procedures are violated.
Who Nolan Wells was, like keeping his memory alive, because from all accounts, he was a good dude. He was raised to be respectful, hardworking, loving, caring, generous, goal-oriented. All these things that you want your child to be. He was all of that.
Here's what I want to leave you with. Nolan Wells was a person, not a mystery, not a narrative. A person. And the people trying to find out what happened to him are operating with incomplete information by design, waiting for systems that move slowly, watching legal processes unfold while speculation fills the gaps. That's frustrating. It's also accurate. If charges get filed, we'll know the DA believes there's enough evidence to prosecute. If no charges get filed, the case might close unsolved. If litigation forces discovery, more facts might emerge. But right now, we're in the phase where procedure protects the investigation and the accused and the victim equally. By keeping evidence sealed until a process is complete, that doesn't mean you stop asking questions. It means you ask the right questions. What evidence is being collected? Who's being interviewed? What does the forensic examination show? Has a grand jury convened? Are charges being considered? Those are the questions that the documented record will actually answer. Everything else is interpretation. Keep focus on Nolan. Not on the theories, not on the narratives. On the person. On what happened to him. And on the systems that are supposed to find that answer, even when those systems feel too slow, too sealed, too distant from the truth.
Everybody's fighting over narrative. Meanwhile, the one question that started all of this hasn't been answered. How did Nolan Wells die?
What do you think should happen next in this investigation? The phone examination, the grand jury decision, the possible litigation. Which of those do you think will actually give the family answers? Drop your thoughts in the comments and follow for coverage as developments actually happen in the documented record, not just in the narratives that spread faster than proof.